Public Meetings Act, PL 1975, Chapter 231. Adequate notice of this regular meeting of the Board of Adjustment of the Township of Franklin has been provided. Would you call the roll, please?
Raymond Bettervid asked to be excused. Laura Grauman asked to be excused. Donald Johnson.
Present.
Bruce McCracken asked to be excused. Alan Rich.
Yes.
Robert Shepherd asked to be excused. Anthony Caldwell.
Yes.
Gary Rosenthal.
Here.
Joel Reese.
Yep.
Cheryl Bagalo. And Chairman Thomas.
Here. We're okay for all of these applications, right?
We have six members present, so.
Okay.
We have
Before
a hardship and we have a certification of non-conforming use.
Okay. Before we get into the regular agenda, I just want to let everyone be aware, in case you're not, we have James Shammy sitting in for newly appointed Judge Patrick Bradshaw. He's not going to be able to be our attorney anymore, so we'll have to look forward to some change in the new year. But Mr. Bradshaw wanted to be here tonight, was unable to talk to the board. He can't represent us even at this point, even though he doesn't start till January 3rd, but he plans to attend one of the meetings in the future, just to, I guess, express his appreciation and everything. But I think it's a great appointment for Middlesex County. Okay, minutes of the regular meeting, November 2nd, 2017. We need a motion.
I move we accept the minutes.
Second.
Donald Johnson.
Yes.
Alan Rich.
Yes.
Joel Reese.
Yep.
And Chairman Thomas.
Yes. Resolutions, Lindsay Steyer Taylor, ZBA 17-00018. We need a motion.
Accept.
Second.
Alan Rich.
Yes.
Anthony Caldwell.
Yes.
Chairman Thomas.
Yes.
Please let the record show that Cheryl Bagalo is here.
Evening.
Late.
C.C. Hamilton, ZBA 17-00013.
Move to accept.
Not second.
Donald Johnson.
Yes.
Anthony Caldwell.
Yes.
Gary Rosenthal.
Yes.
Chairman Thomas.
Yes. Corporate Community Connections, ZBA 17-00001.
Move to accept.
Second.
Okay. Donald Johnson.
Yes.
Alan Rich.
Yes.
Joel Reese.
Yep.
Cheryl Bagalo.
Yes.
Chairman Thomas.
Yes. And Parker at McCarrick Incorporated, ZBA 17-00025.
I move to accept.
Second.
Donald Johnson.
Yes.
Anthony Caldwell.
Yes.
Gary Rosenthal.
Yes.
Chairman Thomas.
Yes. Vouchers, Patrick Bradshaw, Kelso and Bradshaw, December retainer, 865, Taylor Resolution 210, RWJ Barnabas Resolution 560, Border Resolution 29750, Muslim Foundation 385. Is there a motion to approve?
I move to pay Pat, who'll need the money.
Is there a second?
I'll second.
All in favor?
Aye.
Aye.
Opposed? Motion carried. I guess we wouldn't want to be in his court if we didn't pay him. Franklin Associates, appeal of a zoning decision carried to January 18, 2018, if anyone's here for that. The following applications, all right, Gill Petroleum Incorporated, ZBA 17-00008, and Surinder and Reno Singe, ZBA 17-00020, have been carried to January 18th, 2018. No further notification needed if you're here for either one of those. First hearing, we will have Mark and Lori Sletta, Wayne Olson, ZBA 17-00023, and ZBA 17-00024. Currently, the garage and driveway are shared between these two properties. A hardship variance application was received to demolish the garage and rebuild a separate garage on each property, as well as realign the driveway to accommodate both properties at 26 and 28 Washington Avenue, Princeton, Block 16, lots 12 and 13 in the R40 zone.
Mr. Chairman, if I'll just provide a little bit more information on the application for the board's information. Basically, I'm going to read from the report of the TRC. We did one report on both applications because the two sites are located next to each other. Sites are located in the R40 zoning district. Apparently, they've been in the same family since at least 1926. Property line separating the two properties runs down the middle of the existing garage and driveway. The applicant is seeking to correct this situation by eliminating the existing garage and driveway and construct a new driveway and garage on each of the two properties. Even though this is correcting an existing situation where the driveway and garage are split down the middle, the new garage locations on each property actually triggers some new variances, so that's why they're before you tonight. For the application for Mark and Lori Sletta, which is ZBA 17-00023, 28 Washington Avenue, three variances, one side yard of 25 feet, 6 feet is proposed, total side yard of 75 feet and 30 feet is proposed, and impervious coverage of 20%, 16 existing, 23% proposed. And then for Wayne Olson, which is ZBA 17-00024, 26 Washington, one side yard of 25 feet required, 6.9 feet proposed. Total side yard 75 feet required, 18.9 feet proposed. Building coverage of 10% permitted, 10.5% existing, 12.2% proposed. Impervious 20% permitted, 18.6% existing, 22.5% proposed. So in a nutshell, again, the existing side yards are, well, it's basically zero because it straddles, the property line goes right down the middle. The new garages will improve that situation, but still require some variances. And then due to the new, now that each house or each property is going to have its own driveway, I think that's largely driving the impervious surface. Instead of having the one narrow driveway kind of running up the middle, each property now is going to have its own driveway, so that's going to be more pavement. So that's triggering the impervious surface coverage. And then again, both lots also have relatively minor variances from building coverage.
Basically, though, the side yard variances affect each other,
They do.
not the other, not other.
They are, both variances are internal, meaning that they are affecting the two lots that are subject of the application. I should note too that TRC did a report, which is Technical Review Committee. We had no comments on the application. Comments 2 through 5 really are notes, really kind of FYI to the applicant that when they submit for building permit, there are certain requirements that they're going to need to satisfy. So that's putting them on notice that that'll be required when they submit for building permits.
Okay, first, we will wear everybody in. Say something.
Mark Sletta, 28 Washington Avenue.
Raise your right hand, please.
I do.
Lori Sletta, 28 Washington Avenue. Yes.
Wayne Olson, 26 Washington Avenue. Yes.
Is it correct to say you agree with the summary from Mr. Healy?
Yes.
Is there anything you want to add to it? Sometimes it's best not to.
It is. No, it's well covered. It's the garage that's been sitting there right on the property line for all these years, built back in 1926. Just trying to bring it up to code and be more useful to both lots.
I would think so. sounds like it would be. What do you do now, alternate nights for the car to use the garage? Or-
Actually,
There's no room for any cars in
do
our
shift
garage.
around a lot.
Is there anyone on the board who wants to ask a question or needs any more information?
You had no problems.
Right, then we'll open to the public that is here, and is there anyone who wants to make a comment, ask a question about this application? Okay, we'll close. I'm ready to entertain a motion if anybody's got something in mind.
I move to approve CBA -17-00023.
We need a second.
A second.
Donald Johnson,
Yes.
Alan Rich,
Yes.
Anthony Caldwell,
Yes.
Gary Rosenthal, Joel Reese,
Yes.
Cheryl Legallo, and Chairman Thomas.
Yes, good luck with the project.
Wait, we have, excuse me,
Second application.
we have to do this, we have to do them separately. So you'll have to
Okay,
do
now it's
Olson
the-
next.
Need a motion on the second one.
I move to
I think it's 24. 24. Mm-hmm.
I'll second.
Okay. Donald Johnson,
Yes.
Alan Rich,
Yes.
Anthony Caldwell,
Yes.
Gary Rosenthal,
Yes.
Joel Reese, Cheryl Legallo,
Yes.
and Robert Thomas.
Yes, okay, now you're both legitimate.
Thank you very much.
Okay. All right, Dean Mercado, ZBA 17-00027. Certification of pre-existing non-conforming use in which the applicant is seeking a certification of an existing two-family dwelling, 355 Davidson Avenue, Somerset, Block 502.01, Lot 54.01 in the CB zone. They will swear you in right away, and then Mark will have another comment, right?
No, I think the applicant should describe, the applicant submitted a bunch of exhibits, so I think the applicant should basically run through the exhibits, and in essence, what the applicant needs to prove is that the use, it's a two-family dwelling, was in existence prior to the existence of zoning, which came into place in the late 50s, and has been in continuous use up until now. So that's what the applicant needs to prove to the board. And he submitted some exhibits that in his, he feels proves that. So he has to run that, run through that and prove it to the board.
Okay, we'll swear you in, and then I guess we just say, prove it.
For your name and address for the record, please.
My name is Dean Mercado. My address is 35 North Wilson Avenue in Milltown, New Jersey, 08850.
Please switch hands and raise the right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today?
I do.
Thank you, sir.
Thanks for coming out tonight, you guys, on a great shopping night for holidays. I'm here because I would like to officially receive, appreciation from the Township, certification of a pre-existing non-conforming use for a home that I bought in 2002. I was single in 2002, and I bought this home. It was the first home I ever purchased in my life. It was the most money I was ever spending in my life, and I did my due diligence that I knew to do at the time. And I went to the tax assessor's office, and I said, is this a legal two-family house? And they looked it up, and they printed out something for me and said, this is taxed as a two-family house. And I was like, great. In retrospect, after learning from this recent situation, I should have also gone over to the zoning office and asked the same question, but I didn't know to do that. So I purchased the home and hadn't had a problem for 15 years, really, until there was a dispute between my neighbors. And the tenant that I have there now and the neighbor. So the neighbor called every department in the town, including zoning, and I received this notification. Zoning violation, it says, please be advised that you have converted a single-family home into a two-family dwelling without any permits. You must come into this office and apply for a zoning permit or restore the home back to a single-family dwelling. And as soon as I got that in the mail, the very next day I went to the zoning office. I said I did not do that. And started this whole process. So I then contacted the person I purchased the home from in 2002. Thankfully, they had a answer machine with the same phone number from 2002 where I left a voicemail and returned my call. So he then in turn contacted the owner he bought it from in 95. Also took his call, and he happens to be an attorney, the gentleman that he purchased it from, and he wrote an affidavit, which is my proof tonight. The affidavit, or the certification, is from Robert Golden. It says, Robert Golden hereby certifies, I am an attorney at the Law Office of New Jersey, and I have prepared this certification at the request of Dennis Allen Asiello, Esquire, attorney for Dean Mercado, the present owner of the property known as 355 Davidson Avenue in Somerset, New Jersey. I am now 77 years old. My family moved to 355 Davidson Avenue, Somerset, New Jersey in 1946 when I was 6 years old. The house on the property was a two-family structure at the time I moved there in 1946. It is my understanding that the property was owned by my parents, Harold and Dorothy Golden, and by Jack and Stella Zeter. My family resided on the first floor. The Zeter family resided on the second floor. My parents acquired the Zeter's interest in the property in 1966. My mother, Dorothy, sold the property to Robert Paley in 1995. To the best of my knowledge and belief, the building on the property was always a two-family structure. I certify that this statements contained herein are true, and I am aware that if the statements are willfully false, that I am subject to punishment. Robert Golden. So to get this letter was quite a bit of effort to get this letter. By profession, I'm a licensed architect in the state of New Jersey, New York, Florida, Maryland, and so on. I know that to do any work in a home, you need a building permit. I get paid because people need building permits, and I provide them architectural plans sealed with my professional license. I would never do a project without approval from the town. I have been a professional architect representing clients before boards to get zoning approval. I'm fully aware of the rules. I would never break them. So I'm seeking certification that this house has been and possibly always was a two-family home. And the reason why the two former owners believe that and I do is because the floor plan on each level is the same. Usually if you convert, and I have done this, you convert a single-family home into a two-family, you have to modify the walls and rearrange things such that the floor plans will be different on each level. But in this home, they're the same. So with that, I leave it up to you to decide, because in my view, this is a quintessential perfect case of why there is such a thing as existing non-conforming use. Thank you.
Any questions?
Just pass the,
Yes, it is. It's been cleaned up, because I had 7 different violations for that from tenants that had cars, campers, and they're all gone,
It's
and
always
those
been- it's always
violations
been an
are
eyesore,
removed.
yeah.
but it's no longer. And those tenants are no longer there as well.
Is the house empty now?
No, it is not. There's new tenants.
Over here.
It is not empty. There are new tenants there.
2 tenants?
Yes.
So the, the layout, you have a couple other exhibits. You have an appraisal from 2002. Is this at the time, I guess must be the time that you were purchasing the property?
Correct.
Okay, and that shows a first floor apartment and a second floor apartment.
Right.
And that was the layout of the house when you bought the property? I guess
That
maybe-
was the layout for the rooms, but this is not a true survey that shows a stair and so on. It's missing a wall, or rather, it shows a wall that the previous assessor didn't include. But it's in the living room. It's just a corridor in the living room. But you
Okay.
can see that the rooms line up from both assessments from 95 and 2002.
But generally, it looks like there's a living room in each floor. You know, it's basically the same arrangement in each unit, right? A living room and then a kitchen, and it looks like there's 3 bedrooms and a bath in each.
That's right.
And is that basically the current layout now?
Yes, it is. And I pulled permits 3 different times to do work on this home. One was when I initially purchased. I did new roofing and siding and cleaned up the place and did some basic cosmetic stuff inside, like painting and brushing the carpets and so on. And then I replaced the heat system with permits. And recently I got several permits to do work out front and work on the stair and the garage and so on. So I just wanted to add that to having pulled permits 3 different times to do work on the house, but never changing the configuration. They were just sort of smaller things to do.
Hey, in your opinion, Mr. Shammy, the certification letter from Mr. Golden, are we able to, how much weight are we able to attach to that? Because he's not here to be questioned.
Use the mic, please.
I would need to further research the topic to give a definitive answer, but my initial inclination here is that unless it's a sworn statement like an affidavit, it wouldn't be, considered as testimony or as, so I have no reason to doubt what's written in the certification, but without the affidavit or the notary, notarizing the, authenticating the signature may not account for, hold the same weight as an affidavit would. So I would recommend then that if possible, this individual be here to testify.
Okay, and that's just referring to that particular piece of evidence, not
Correct.
any other things that the board might decide to consider. Any other questions, or any questions, period?
So how does the stairwell go to the second floor? Do you go in the front door?
It's actually represented, let's see, on the 2002 floor plan, by the lines right next to the kitchen. Those are the stairs, and there's a door on the side of the house there. So the stairs are not drawn in, but that's the 2 walls for the stair.
All right, so for the upstairs unit, there's a side door.
There's a side door for both units, actually.
The second floor unit does not enter through the front door.
No.
Now, what type of heating do these 2 units have?
There's a radiator heat system in the house.
Okay, in the basement
Yes,
that they both share?
yes.
And do they have 2 different electrical connections? Electrical?
They do,
utility?
and
Okay.
gas.
So the two tenants pay two different, their own electric and gas bills?
Correct.
Okay, but there's one, so there's two furnaces in the basement?
There's one furnace, but there's a separate gas for the,
Mr. Mercado, can you keep your
Oh,
mic
sure,
up
sorry.
because it has to be recorded?
there's one furnace, but there's two gas lines and 2 meters because there's cooking on the second floor kitchen that they pay for their own.
Okay,
no,
but
but-
they share the heating,
Correct.
okay.
They share the heating, so they each have their own thermostat?
The thermostat is located on the first floor.
If it's a two-family, then shouldn't they have their own heat?
We tried to set it up that way, but it just works better with the one system for it to be on the first floor only. And the reason why that has worked is because when I had people there, they were generally either really good friends that one person got the other person to live in the other unit, or they were family, and it just has worked. I've never had an issue with it.
Does that legally constitute a two-family dwelling?
Well, I mean, two things on that. I mean, number one, I not really sure what relevance it has to the board's decision. I mean, it's really, if anything in terms of the township dictates that, it would be a code issue. And, so the construction department would have to deal with that. But then, really, just in terms of what the board is dealing with, you're not really approving a use. This isn't a use variance or site plan. You're just here to determine, was this use in place prior to zoning, and has it continued to be in that use since? That's really the only thing the board is supposed to be determining at this point.
I mean, my only question is, if it's a two-family dwelling, each unit, if you go out and rent an apartment in a two-family, legal two-family dwelling, you usually have your own thermostat.
And that's a code issue. I don't know. And it's either a code issue, it's either a code requirement or it's not. And that would be up to our construction department to enforce. I mean, I know, just anecdotally, I know myself, when I first, it was 20 years ago, but I mean, I lived in an apartment building, and there was one heat going through 400 units, and they would pump that heat, and I had to open up my window so I didn't, so, I mean, that was 20 years ago. I don't know if the code's different now, but, and I just don't, respectfully, I don't think it's really the board's concern.
Other questions?
I have a question. So you didn't submit any other pictures other than this one? In the kitchen upstairs, is there anything architecturally that leads you to believe that that was installed before 1946? Or
No, it's, all the walls are plaster, old construction. I mean, the appliances, I don't think are from 1946. I replaced them. Stove and the refrigerator.
All right, so the only architectural clues you're offering us are the outlined floor plans here.
Yeah, I mean, this is something that Golden stated, and the previous owner, that they always assumed it was a two-family home from its construction because all of the walls lined up, going up. So, and I'm echoing that as well, as an architect.
Excuse me. Everything you've said so far, it describes my house. It's a family, and walls line up, the one boiler for the whole house. It's all the same. It was built in early 1900s, so I can understand your position.
Thank you. It's a difficult place to be
Yeah.
when, you own a house for all these years, and then all of a sudden, because of a dispute with a neighbor, that all of a sudden I'm being accused of doing something wrong. I did not, absolutely. I gave all these other documents, like the advertising of it being sold to the former owner before me as a two-family, and so on. So, thankfully, Golden is still alive. He's 77 years old. The reason why my attorney asked him for this certification was in the hopes that it would be accepted by the board. Get him here would be very difficult. So he signed this and delivered this for us. He's an attorney. So hopefully, that's not an issue there. I asked the tax department and the different departments for their earliest records, and I was told that they don't have anything going back nearly that far back. So in order for me to prove this to you, one thing I would want to do is get the records of that time, but they're not available to me. So I had to find Robert Golden, who thankfully was alive, to share with you that since he was 4 years old or 6 years old, it was a two-family home.
Just out of curiosity, how long have your neighbors been living there? Ones that are complaining.
My neighbors, I was friends with the former owner of the home, and he passed away.
Oh.
And his son moved in, and that's when the problem started. So-
Would have been good if Dennis Osiello would have notarized his signature first.
Would it have made any differences if this was notarized?
It would, in my opinion, yes, it would make a difference. It would authenticate the signature so that it would have
Well, I
the
know
same-
Dennis, and I'm surprised that he didn't notarize this certification.
And that's, just to put it bluntly, I'm sure Robert Golden exists. I'm sure he's 77 years old and he's an attorney, but literally anybody could have written this. Just legally, anybody could have written this.
Yeah.
So,
Basically,
I
what I'm
think-
saying, yes, in order to authenticate the signature to guarantee that the person is the person signing, we would require a notary or an attorney to.
You could take the person, drive them to a local bank or wherever.
in my understanding, and refer to the attorney, but my understanding is that having something notarized or an affidavit is basically the minimum. Usually it's preferred to have the person here, so in case the board wanted to ask that person questions, that's what usually commonly happens in these situations. But
My understanding is the same, that's correct.
Is the gentleman still in this state? Is he still in this town?
No, I don't have his address. My attorney, Dennis Osiello, found him and got this letter from him, but I did not meet with him. My attorney did.
perhaps if I could ask the board, based on what you've heard so far, do you feel any need to ask Mr. Golden questions? Or do you feel you might be satisfied as long as this document was notarized? Is that, and then perhaps you can give the applicant some direction as to what you expect of them?
Personally, I just think that if it was notarized, I don't think we need to ask a gentleman 77 years old to come in.
Yeah, I agree with that too. Personally, I'm satisfied with it the way it is right now.
And I think for the sake of offering testimony that the notarized document would probably suffice.
So, perhaps, Mr. Chairman, perhaps what we can do is, if that's the direction it seems the board is going, perhaps we have them come back at a subsequent meeting with the document notarized, and we can put them on first. I mean, it's not going anywhere. It's already a two-family dwelling. So, we can put them on at the first session at the next meeting. What would that meeting be?
I think that makes a neater, cleaner application for the applicant too, then there's no more doubt down the road. We went the extra step to get the verification, and like you said, it's not going anywhere.
Just for my,
And we can do this at the pretty quickly, as fast as the applicant can do what he needs to do. We can put this on the schedule in a moment. Does this need to be advertised the same way?
No, they didn't notice. They didn't have to notice for this. But we should, for the benefit, and we should indicate what date it's going to be carried to.
All right, but otherwise, we can do this quick as it can be. The information can be given to us.
The next meeting is January 4th, but that's provided that you can get in, you said you didn't even know where the guy is, so that,
Yeah, I
that
just
means
have to-
Dennis has to get in touch with him, and, if you can get the document, the meeting is January 4th. If you're unable to do that, then the next meeting is the 18th after that. I don't think it should take you any longer than a month or so, right?
Hopefully, he's around for the holidays and stuff.
Okay.
Do you want to just say the 18th to give yourself a little
I
bit extra
think that's
time?
probably wiser,
Okay.
just because of the holidays.
Why don't we do? So why
And
don't
we will carry this to January 18th.
So would this be something that I could just submit when I get it, or do I have to bring it here and show it to you the first time? But I do need to return for another meeting? Okay.
You can submit it to me at the office, you can mail it in the same way you did with your schedule letter, and I will, as soon as I get it, depending on what day I get it, I would know whether to put it on the 4th or the 18th. And then in their packets, they will have that, before you even get here, they will have the copy of the certified or notification, okay? So just, call me or just send it to me the same way you did the schedule letter, and then that will indicate when you're gonna have your meeting.
Okay.
I mean, we'll try for the 18th, like you said. If it takes any longer, then we'll go into February, but we can communicate. We don't have that here. You and I can communicate on that, and then when you give it to me, they'll be submitted to them.
Okay.
Okay?
Thank you.
Welcome.
Okay, then we'll carry this right now to January 18th and then go from wherever we need to go. All right, anything else?
Thank you.
Welcome, and we'll adjourn.
So move.
Second?
Favor? Aye. Meeting adjourned.
All right.